It's Sunday, 1st June 2025. Nomination day is scheduled for 14th July 2025. And the so far, in my estimation, unofficial announced date for election is the 1st of September 2025. Welcome to Nation Watch. Thank you for joining us. Stay with us. This program is going to be very interesting and we're likely to go over time. We've waited about 20 minutes or so beyond the 12 o'clock hour to ensure that those who are coming from church are safely home and have taken up their positions in the favorite and most comfortable locations in the home as we discuss two very, very important issues today here on Nation Watch. The first we will be discussing is we will be bringing you an update on the Adriana Young case. And then we'll be discussing the Guyana Elections Commission and Elections 2025. We will be joined by Dr. Dexter Todd, attorney at law, who will be bringing us up to date with what's happening with Adriana's case. And in studio with me is Mr. Vincent Alexander, Commissioner, the Guyana Elections Commission, who will be taking us through the conversation on GCOM and Elections 2025. So call a friend, call a neighbor, and tell them Nation Watch is on. And we have two very, very important issues which we are bringing to the nation's attention today. Let me bring in Dr. Dexter Todd immediately as we get into our conversation. Dr. Todd, thank you for joining me on Nation Watch today, Sunday, 1st June, and welcome back home. I know you've been on a very, very busy schedule, championing the cause of justice for the Guyanese people. Welcome, sir, to Nation Watch.
Thank you so much. Thank you so much, Mr. Williams. Thank you for having me. And Good afternoon to your viewers.
Right. So, Dr. Todd, will go immediately into some video clips. Mr. Travis Chase, senior reporter at HGP Nightly News, conducted an interview outside the facility where the actual autopsy was being conducted by Dr. Carol Terry. He spoke with Dr. Terry herself, and we've taken 2 or 3 clips from that interview to bring context to our conversation. So here we go with the first of those clips.
Find any evidence of trauma?
No, I did not.
Secondly, the first autopsy ruled that Adriana Young drowned. Would you come to that conclusion?
At this point in time, I would not come to that conclusion. I think that there's a lot of information that needs to be gained, a lot of investigation that needs to be done. Drowning is a diagnosis of exclusion, and by that, it means that you have to exclude other potential causes of death. And oftentimes, when a body is found in water, the assumption is that the person has drowned. There is nothing at autopsy that is diagnostic of drowning. So again, that's what I mean by saying drowning is a diagnosis of exclusion. And in this case, what I have been told regarding the circumstances are so suspicious that I really think that there needs to be a very thorough investigation, and I would want to know the results of, say, toxicologic testing or drug testing from the first examination, as well as any additional testing that was done in accordance with the first autopsy.
3 very important points here, which we'd like to ask you, Dr. Todd, to speak to us on. 1, drowning is a diagnosis of exclusion, and it comes after ruling out all other potential causes of death before reaching that conclusion. 2, there's nothing diagnostic of drowning in an autopsy. And 3, the need for a thorough investigation. And I suspect that the need for a thorough investigation refers directly to the first point of drowning being a diagnosis of exclusion. Dr. Todd.
Yes, thank you so much. Now, I believe the complexity of the whole concept of drowning was, I think, examined by Dr. Terry. We had an opportunity, and I want to say this from the onset, that we saw at Gwinnett County something that we have never seen before. In that room, with Dr. Terry being the forensic pathologist, were other experts, crime scene expert, cold case expert, anthropologist, someone who is an expert at that. And what we found, so it was a full team of persons who surrounded this child's body. And as the dissections took place, and I think I want to say this, that when Dr. Terry spoke to the autopsy being thoroughly done, she was speaking to the dissection, because clearly how the body was dissected, clearly she saw that professionals were at hand here. All right. And so she didn't find that the dissection of this girl's body was outside of what a very trained sound pathologist will do. So she spoke to that. Now, this whole concept of drowning is, especially when you're dealing with a criminal investigation, one has to be very, very careful. And I think that is where we have the problem here. We have a problem here because there was no synergy between the investigators' investigation and the entire autopsy which was done. So even the preliminary, and I believe that is where the wake up call is, because even where the preliminary results came out, that we are dealing with rounding here, it was very premature, and it's something I was seeing from the onset, that you couldn't, from a preliminary standpoint, even before the completion of a criminal investigation, be going down the line of making a pronouncement that you're dealing with rounding here, because what you have Terry clearly pointing out is that this really is a conclusion that must come after the elimination of several other causes, and so you did not even have that. And I think Dr. Terry went on further to say, this is sometimes the misinformation that we have out there, that because of the fact that we did not see trauma, one goes down the line of saying, well, then there is no foul play. And she dismantles that notion. She dismantles it, because that is not in all cases. And I think one of the problems that we have here is that three of the respected pathologists who conducted this examination did not get an opportunity to speak to the public or to speak openly in relation to how they derive at that findings. And I believe in their language, they would have been a lot more careful in not misleading a public, the country, in believing that because there is no trauma, then you rule out foul play. Dr. Terry, in explaining, and she took time, and I believe this is why this second autopsy brought some form of real satisfaction to the parents, because she took the time to sit with them and to explain to them that not in all cases where there was foul play you are going to see trauma. And she demonstrated with using a live person at the clinic, that if she pressed on a particular part, and she demonstrated that if pressure is put here and the person is unable to breathe, the person can die.
Will die.
So yes. And so she says, not in all cases, even if you dissect and you don't see some form of bleeding in the skin or seeing signs that pressure was put there, you can't rule out foul play. And that is why she was saying, in this particular case, a forensic pathologist, in order to come to a conclusion, must work very closely with the investigation, who will look in the totality of the circumstances of the entire matter. So where in this particular case you had um, videos showing the girl was in the pool, then you don't find her in the pool. And then you find a number of persons who checked and didn't find her in the pool. All right? You needed to examine all the circumstances before you can even pronounce and come to drowning.
And
Because
that
what she
means
was,
and that means interviewing all persons who were present,
yes, yes.
and that has not been done.
Of course, has not been done, because this when you're dealing with drowning cases, it can be very, very tricky. Something blew my mind just listening to her explanation to the family, in a very, very detailed way. And what I think we keep missing is that, and this is the point, I want to use her exact words, because sometimes we go down the line of saying, there was some form of misquoting, and I don't want to misquote here at all what she said. Now, she said clearly that when she talked about drowning being a diagnosis of exclusion, and it means that you may have to exclude other potential causes of death, because oftentimes, and this is my point, oftentimes when a body is found in water, the assumption is that the person has drowned. Now, she went on to say that a person being in water and a person drowning as a result of whether the person couldn't swim, accidental, what the case may be, the signs that you will see would be the same. Placed in water, drowned in water. Same signs you will see at an autopsy. So this is why it's very careful, that one has to be very careful not to try to say, well, okay, because a person is found in water, then of course you're going down the line of drowning. And I believe that is intellectually sound. Intellectually sound.
From the interview, and on behalf of all Guyanese, I'd like to thank Mr. Travis Chase for his vigilance, for his interest, and his action in pursuit of truth. By traveling there at his own expense, and ensuring that he provided the necessary interviews and reports to us here in Guyana. Let's look at another clip from that interview with Travis Chase and Dr. Terry.
And it appeared that it was. There are some minor differences in techniques of dissection, but I think the first examination was conducted thoroughly. And as I'm doing this examination, first and foremost, I'm looking for any trauma to the body and making sure that there is no trauma that has been overlooked in the first examination. And also in going through the previously dissected organs, looking to see if there's any trauma to them as well as any disease processes at play. And also at this point in time, I'm collecting specimens in case additional testing needs to be done. Again, realizing the optimal specimens are from the first examination, but I'm conducting this examination keeping in mind that I'm not going to have a chance to go back. And so anything I need to do at this point in time. And so I think I overcollected things, but again, I don't get a second chance to go back and be thorough. So those are the things that I was mindful of in the course of doing this examination.
Right. Dr. Todd, you dealt with much of what she said there in your first presentation. So we go right into, I believe, our final clip and
How
get your
problematic, Doctor, how problematic would it be to say that Adriana Young drowned?
Again, I think it is problematic because of drowning being a diagnosis of exclusion, and what I was told regarding the circumstances of her disappearance and death and the subsequent finding of the body in a pool where it reportedly had previously been searched and she was not there. So that I find very disturbing. It's not like she was seen playing in the water and then a little bit later is found under the water. This, as was told to me, she was seen in the water and then disappeared. And the pool was searched, she was not there, and then sometime later is found in the pool. That is disturbing because I don't think you can simply write it off as this child drowned. You've got to be concerned, did she die sometime earlier and then was placed in the pool? Because there's not going to be any good way to discern whether or not that happened. That's going to require an investigation and additional testing to see if there's anything that may be amiss, such as unexpected drugs in her system or any indication of a sexual assault. Things like this need to be considered and need to be looked at, given, again, the circumstances that were reported to me.
Right. So a thorough job done, a sit down with the family, full disclosure by the lead pathologist there, as you explained, Dr. Todd. In terms of a final report of this second autopsy, where are we with that? I know that she did say that she took some samples and she may have gone a little bit over collecting because she wanted to be safe, recognizing that she wouldn't get a second chance. Where are we with the testing, the final results of the work of Dr. Terry and team? And secondly, have you or has the family of Adriana Young benefited from a copy of the report from the first autopsy conducted in Guyana by the three experts?
Well, I would say that there was some form of reluctance to disclose to the family the preliminary results from the first autopsy. Now that we are aware through the media that the completed report or the final report is available to the police, I was tasked with writing on behalf of the family to get a copy of the final report, which
So you have not benefited from it yet?
no, not as yet. And this for the completion of the second autopsy, Dr. Terry awaits that, because what was explained to the family in my presence is that sometimes when we're dealing with the toxicology examination or tests, there are a number of things that you may want to ensure is done in order for you to conclude that the entire exercise was thoroughly done. And this is not only a case where you're just testing for various traces of drugs, but also if there was a certain tests which were conducted for other chemicals, in the system is important. Now, from the preliminary, and again, I speak on the basis coming from what was disclosed to the public. From what was disclosed to the public, we saw that the final result says that they found no traces of drugs in the blood or in the system of this young girl. They did not speak to whether there was any further tests being conducted in relation to chemicals, etc. And so that again was, of course, related. That information was given to Dr. Terry, and so Dr. Terry made sure that there are a number of samples from the body, which was, of course, is now being kept by the lab, so as to see whether there is any further testing to be done. Now, she did make it very clear that some of the best tests comes from the first autopsy, or the samples
Yes.
taken from the first autopsy, because
Yes.
at that point in time there would have been no artifacts which would have been introduced to the body. Now, if those were not done and those samples are no longer available, then we will have to go to the second samples which were taken, which will, of course, she did explain, will take a longer time for lab analysis, because now you're looking at a number of exclusions of those artifacts before you actually get to what you want to do. So we're hoping that we don't have to do that, and that at least the police will be able to share with the family the not only the results, but inform the family about those samples which were taken, so that if there is anything additional that Dr. Terry believes is required, then those samples will be available.
Right. Your expectations, I really admire your confidence, your confident outlook, Dr. Todd, because what we are reading in the local media is that the police have completed, are on the verge of completing their case file, and they are to send that file to the Director of Public Prosecution for legal advice. It would appear from all that we've been hearing from the president, who has inserted himself in this matter very, very early, and who has made some pronouncements on this matter very early, prematurely, I believe. And it is the anticipation of most people that the DPP is going to shut this down. And one of the easiest legal ways for her to shut it down is to order an inquest. So that basically what will happen is that there'll be this inquest, and there will be an adoption of the autopsy report that they have, and everything is done. From your end, Dr. Todd, and from the family side, where do we go now? Do you go to the high court in this country to get the necessary investigations done to bring closure to this matter, and even if it means possibly prosecuting person or persons in this particular case? Are you, is the family prepared to take this to the international arena, maybe CARICOM, the Commonwealth, the United Nations, Rights of the Child Commission? Where do we go with this from here?
All right. The approach legally, I believe, is going to be, and I'm going to be very guarded how I give the strategy, because I think I had a very, I believe, fruitful meeting with some of the legal experts in various fields, internationally and locally, as to mapping out the legal journey in relation to this matter. And I think we're going to be tackling it from two standpoints. One of the first leg that we're going to be looking at, we are going to be challenging the first autopsy's findings and the report. And we're going to be doing that because we believe if left in the way it is, it is problematic for precedents in relation to criminal investigations in Guyana. Um, and so some of the things that we will have to do, because it is a cause of concern internationally, that we have treated this whole investigation of drowning a bit too much by textbook, so to speak. And we have not really connected a very all the various components of this investigations to come to that findings. And so there is going to be a need for us to revisit the first autopsy. Now, report. The second leg of this, of course, will be to look at the police's investigation. Now, I can tell you that by itself will be a challenge because on maybe the first case that we've had is the case of um, Henry Green when that case was brought before disclosure before the then acting Chief Justice Ian Chan, um, where the action was successful in having disclosure. So Henry Green, who was the commissioner at that point in time, before the director of public prosecutions had made certain recommendations, and even before the charges could have been instituted, there was an opportunity in which the entire investigation, of course, was reviewed. Now, the entire investigation in this case will have to be reviewed. And so we are now mapping out what are these various steps to challenge that in a court of law. Now, I can tell you that we are also going to be considering, and this will be clearly for various organizations, to plead with government to hold a commission of inquiry in this regard. So, with a commission of inquiry, you get an opportunity to interrogate all that was done in this matter, and for
Or not done.
or not done, yes, and to make certain recommendations. So we are also considering that. But of course, the third leg, of course, again, that is falling back in the hands of government to have government's approval in that regard. And I don't know whether that is what that is a posture that they are going to take in this matter. So we're going to have to do it. But I can say that this particular matter, in terms of the legal leg, will be assisted by a number of lawyers internationally who are concerned about the president being set in relation to how cases of homicidal drowning are dealt with in Guyana, and to have that properly defined in a sense. So that is going to be one of the first areas that will be dealt with in relation to the legal position.
Thank you very much, Dr. Todd, for bringing us up to date with the latest position regarding Adriana Young's unfortunate death. A nation mourns. A nation mourns not just for a child, but for all of the children of this nation. A nation mourns for our children and for the breakdown in the rule of law, for a breakdown in the justice system. And on behalf of all Guyanese, Dr. Todd, I wish to extend to you sincere gratitude for the work that you're doing and for the rest of your team, also to those international partners who have stepped up to help us to bring some sense to this entire situation. Thank you very much, Dr. Todd, for joining me
Thank
on
you so
Nation
much.
Watch and bringing us
Thank you
up to
so much.
scratch. Have a wonderful rest of the day, sir.
Thank you.
We'll now bring in Commissioner Vincent Alexander, and I'm pretty sure that before we get into our conversation, Mr. Alexander may wish to share his thoughts briefly on the just concluded conversation with Dr. Todd. Mr. Alexander, you've listened to the conversation rather intently, and I detect that you may wish to offer your own views on this matter.
Thank you very much, Mervyn, and good morning or good afternoon, I think it is, to the viewing public. I listened intensely to this response of Dr. Todd to the various questions which we posed to him. I must confess I'm not altogether professionally unacquainted with forensics, and so I have a professional interest as well. There's one term that has come to mind as he spoke, and that term is simply holistic, holistic, holistic. That this matter ought to be dealt with holistically, both horizontally and vertically. Horizontally means that at every stage of the investigation, it should be holistic, and I'm going to give an example as to what I mean shortly. And even as we go along the stages, there should be a holistic approach. And by holistic, I think Dr. Todd gave us a good example of what occurred in terms of the autopsy in the US. Not only was the pathologist, and I dare say forensic pathologist, there, but you had a plethora of other professionals who were present, so that the matter could have been looked at not only from the standpoint of pure medical autopsy, but from the standpoint of an integrated system, the anthropology and all of the other aspects that could impact what actually occurred. And I say that because here is where we have had a big problem in Guyana. Apart from all the problems we've had a big problem in the case where the government brought a forensic specialist, so to speak, who, in my humble opinion, from the reports, and this could be refuted, seemed to have done what I call a desk review. This is not a forensic person who came and did scientific forensic work, but seemed to have done a desk review relying on the work done by the police. And so pronouncing on the work done by the police and what could be discerned from that work. Now, in that regard, I think the word holistic is, again, very critical. If you're going to investigate a matter like this, apart from the medical people, there are all sorts of other people in all sorts of science that should be engaged. And the forensic expert who came should really have been a part of a team, if not leading a team, with these other experts who we then send off to do specific investigations in relation to the matter. For example, I haven't heard as yet that the water in the pool was sent for testing, so there could be a comparison between the water that was in the pool and the water found in the girl's body. So critical.
Well, it's interesting.
I haven't heard that at all in all of this.
It's interesting that we know that the area was not determined to be a scene of a crime. It was not protected.
Definitely.
It was not preserved. And therefore, anything that flowed from there would have the kind of dark shadows behind it.
But even
that
the
these have.
water of the pool, in all of these circumstances,
By the time, Miss Alexander, this thing is painful. By the time there was word that the police were going to send sniffer dogs,
things
the
happened,
body showed up.
started to happen. That's
By the
interesting.
time there was word that they needed a sample from the pool, it was drained. Every step of the way, it appears as though the hotel operations was ahead of the game, right? And I am going to tell you now that all this nonsense they're talking about, um, the body may have been there and floated after because of tropical this and that, absolute balderdash. The commander told me that he and the police searched the pool the evening of the day on which the child went missing, and again on the morning of the day on which her body was retrieved from that pool. And there was nothing or no one, no person or no body in that pool.
And here is why I'm contending that the word holistic is a critical word. And I said holistic horizontally, because horizontally holistic means that all of the places, all of the elements at a particular time would have been the subject of thorough investigation. And vertical means as they went along, they would continue on the horizontal planes at the vertical points to do a holistic. So that this is a critical area of concern, that the investigation beyond the autopsy seemed not to have been the required quality of investigation. We don't know what the police actually did. We don't know. We know the forensic
In a word, nothing.
expert seemed to have done a desk review and therefore really did not apply any forensic expertise to the case at large. He applied his expertise to doing a desk review. But you know, Mervyn, in all of this, I think that we seem to have lost connection to another aspect of this moment. Of course, the girl's death is critical. It has to be investigated. Justice has to be had for the family. But what occurred after this death, and probably during, exemplifies the sorry state our country is in. And that is a matter that should not be left unaddressed as well. The fact that the police could have shot upon the so-called protesters at Lenora, who were not involved in any violent act, and that the police again shot at the so-called protesters at the GPHC before
And in Virgin Nugent, I don't know that it even was a protest. And in the Namstel, shots were fired and people's louver panes were broken when they were sitting in the veranda a few inches from where the bullets hit the windows. So
this is the point I'm making is this: two things. One, the people's protest was not merely related to this girl's death. This girl's death was another event in a continuum of events that point to a state of crisis in our country in terms of governance, in terms of security, in terms of safety. And that the police, the way the police acted, also points to a regime that is repressive in its attempt to control, dominate, even if it means covering up wrongdoing. And I think those are critical things that this situation has exemplified. And those are things that should always be in any analysis of the moment. What we've had is the autopsy on one hand, and we have now the question of terrorism on the other hand. what's in between that death in terms of the citizens' reaction, in terms of the police reaction, which in itself allows one to make an analysis of the state of affairs in this country, is being omitted.
Let's get down to what is contributing in large measure to the state of affairs in our country. I believe it was on the night of the 25th of May that Mr. Irfan Ali, in an address to the nation, inserted as part of his address the announcement that elections will be held on the 1st of September 2025. The president indicated that he had consulted with the chairman of GCOM, and based on that, he named the 1st of September. Yourself, Mr. Corbyn, and Mr. Trotman, commissioners nominated by the opposition, had a press conference during which you pointed out that prior to the president's announcement, you were at the level of the commission considering a work plan which had proposed the 22nd of September as the earliest possible date by which the commission was in a position to conduct general and regional elections in the country. We will discuss the statement that GCOM issued after. Talk to us about the proposal that was on the table and how the president's announcement came over to you as opposition nominees on the commission and how it affected you in terms of the work that you're doing.
First of all, Mervyn, as is public knowledge, GCOM was discussing a work plan that was prepared by the Chief Elections Officer and brought for our discussion and our fiat, our consent, our approval. The first point I want to make is that subsequently, this Chief Elections Officer sought to tell the public that he had not presented a work plan. That what he presented was a list of activities. Anyone who sees the document that I refer to as a work plan, and that he calls a list of activities, and the subsequent document which has now been approved as a work plan, you would see that in terms of title, in terms of format, and in terms of what constitutes the document, they are one and the same except for being versions. They are one and the same except for being versions. So that we have a chief election officer who's prepared with the fiat of the chairperson to put into the public domain what's essentially a crass lie about the occurrence in GCOM. It's the first point I want to make. The second point I want to make is that the work plan that we were discussing, which proposed the 22nd, because we sought, it sought, not we, it sought, and we were concurring relatively, to have timelines that are conventional and best practices. What do I mean by that? It sought, for example, in the instance of claims and objections, to provide a period somewhere in the vicinity of 21 days to cover claims, objections, appeals, etc.
Normal practice.
Normal practice, and I dare say best practice. In the work plan which has been presented to facilitate an election on the 1st of September, those periods have been reduced to days like 5 and 7 days. And so the public need to understand when we say we're not in the state of preparedness, what we mean. It means the GCOM is now cutting the corners to accommodate the date rather than embracing the best practices and the conventions which GCOM itself had established and which had informed the CEO in his preparation of the initial work plan. There is this contention the president has a right to call the date, and I'm not contending the president has a right to call the date, not contending that at all. But the convention in that regard has also been for the president to consult with GCOM and on the advice of GCOM, then exercise his prerogative. Because the president should not want to call a date for us to have an election that's not properly managed, properly delivered. And GCOM is the one to advise on which date is best. So notwithstanding any contention about we should be ready in 90 days and all of that, the fact of the matter is that we should be advising the president based on our readiness, incorporating the best practices. The president has now apparently been advised based not on best practices, but based on expediency.
Inspired by him, perhaps.
To suit his date.
Yep.
To suit his date, as opposed to GCOM being frank and open with the president and saying, here is what's best suited to produce a free, fair election in keeping with the best practices and the conventions that we've embraced. But that the president got that advice in itself raises a number of questions. Well, the questions it raises is that, was the chairman authorized, so to speak, to tell the president that we were ready, when in fact, as of May 20th, we all were discussing a plan for September the 22nd. On what basis did she tell the president we would be ready for September the 1st?
And on the 23rd, you were in conversation and meeting, discussing this work plan on the 20th. And on the 23rd, she had this conversation with the president. I want to read, I believe, 2 paragraphs from a GCOM press release following the press conference of the 3 opposition nominated commissioners. And I'm quoting here directly from GCOM statement. Let's see what's the date of the statement. 28th May. The chairman, this call was on the 23rd of May. Let's see the particular area I want to quote from is right here. It says, the assertion that President Irfan Ali's naming of September 1st, 2025 as the date for general and regional elections was apparently based on unilateral advice by the chairman of GCOM, because that time frame was not in keeping with the work plan that was last discussed on May 20th, is misleading for the following reasons. The chairman received a call from President Ali on Friday, May 23rd, 2025, inquiring whether GCOM would be in a position to hold the elections within 3 months. The chairman asked the president to allow her to consult with the chief elections officer before she gave him an answer. The chairman did consult with the chief elections officer immediately after her exchange with the president. The chief election officer informed the chairman that, in anticipation of a possible need to conduct elections before they became constitutionally due within 3 months, he had prepared a draft work plan to be in a state of readiness to hit the ground running should the need arise. In that regard, he further informed the chairman that this draft and the commencement of the 3 months on June 1st, 2025, placed election day at August 25, 2025, that is, within less than 3 months. It is specifically in consideration of this circumstance that the chief election officer advised the chairman that the secretariat will be able to conduct election within 30 months. Now, My recollection of your press conference, Mr. Alexander, is that you were discussing a work plan on the 20th that proposed as the earliest possible date, September 22nd.
Correct.
My understanding of the principle of consultation here is that the chairman consults, well, the president consults with the commission through the chairman,
Correct.
and premised on the position of the commission, that constitutional body, the chairman provides information to the president.
Quite correct.
This statement appears to me to be an open admission by the chairman of the commission, a retired justice, that she did not consult with the commission.
The statement undoubtedly, by virtue of what it says, points to the fact that there was no consultation with the commission. Not only does it point to that fact, but the fact of the matter is there was no consultation with the commission. It is the commission of GCOM that has a mandate to conduct elections. It is the commission of GCOM that has to make a decision in relation to what advice is rendered to anyone on the conduct of elections. And in this instance, clearly the commission was not involved in the advice which was rendered, and the extent to which the chairman sought to render that advice, having heard from the CEO, is the extent to which he was unilateral in her, in the advice which she gave to the president. And there's nothing she can say or do that would make it otherwise than that she acted unilaterally.
Now, there was a second release on the 30th of May, a release which speaks to the approval of a work plan. And the approval of this work plan has to do with satisfying, well, GCOM satisfying itself, and by extension satisfying the president, that it was in a state of readiness to conduct elections on the 1st of September. I recall that there was in fact a statutory meeting, and the news reports that I saw said that the three opposition nominees on the commission walked out of a particular meeting, which rendered that meeting, in my view, devoid of a quorum and incapable of making a decision. Did you participate in a subsequent meeting giving your vote to the approval of this new work plan?
I did not. I participated in a subsequent meeting. I did not, at any point in time, render a vote in support of the plan. I could hardly do that for two reasons.
And 1 second, please. Is this the same position taken by your two colleagues who are opposition nominees?
In fact, in that meeting, there was no vote,
There was no
so
vote.
to speak. There were contributions made in relation to the plan. I can say unequivocally that I did not make any contribution to that plan at that meeting. I did not say anything whatsoever, and was not required, was not requested to give my fiat. In other words, there was no vote, and so I didn't have to say yea nor nay.
So how is the approval?
I'm coming to that. I would also contend that for all intents and purposes, Commissioner Trotman at no time gave his approval to the plan. I would go on to say that Commissioner Corbyn raised a concern about that, about the approval on the grounds that in the plan, there was still a particular statutory date which was being defiled, and that he would wish to have that statutory date determine the matter pertaining to the statutory date determined before we conclude that this plan in its completeness is the plan we work with. That matter has not been finalized. So the plan was approved in the face of contributions from the other commissioners who were absolute in their support for the plan, for the chairperson who said she had no problem with the plan, and in the face of myself and Commissioner Trotman not giving support to the plan, and Commissioner Corbyn having caveats about the plan. So that is what eventually occurred.
Well, the chairman cannot have a problem with a plan that justifies her unilateral action.
No, it was a fait accompli. Plans of fait accompli. What they were doing in sense was giving retroactive approval to something that already occurred. And that in itself is a problem.
I have two questions on the chairman's actions. One, the chairman advised the president on a possible date for election without the commission being given an opportunity to consider the work plan that became the basis for advice. Secondly, the chairman advised the president of a date for election when
The chairman did not advise me.
well, on the possible date, a possible date by which
She advised the president that the elections could possibly be held
By a certain
within
date.
3 months.
Right.
Within 3 months.
right,
And he picked a date.
right, fine. But she did so when the commission was actively considering a work plan which did not contemplate the nature of advice that she offered the president.
Quite correct.
In view of these two facts and her unilateral action, is the chairman's action lawful? Is the chairman's action in keeping with her mandate as the holder of a constitutional office named chairman of the Elections Commission?
There's a technicality to that. Whether her action is lawful or otherwise, it will not impact the decision because the president has the prerogative to call the date.
Yeah.
The law does not provide for the president necessarily to consult. And that is what people are falling back on, that he has the prerogative to call the date.
Mr. Alexander,
And he has exercised that prerogative.
nobody is denying that. Nobody is naysaying that. The president has the prerogative to name a date.
Correct.
The president's naming of a date has got to be premised on something. That something is the commission's readiness.
No, that is a logical conclusion. But we're dealing here with a strict legal situation. And we have seen the way in which our courts have dealt with these matters. The law has no proviso, and that there has emerged a practice does not mean that that will supersede the letter of the law and the president's prerogative to call a date. So that in fact, her to have given the advice that she gave, which she should not have given, from a standpoint of GCOM's operational procedures, etc., is acting in cahoots and providing the president, well, not providing the president has the prerogative, but providing the president with a logical reason for calling a date that will not bring into question his commitment to an election that we are prepared for. And so what she does is to give the president moral ground to doing something which
Something that is hardly claimable by him.
it should not be done. And I tell you why it should not have been done. We know, as I have mentioned earlier, that the plan which we're now proceeding on is a shortcut plan. An election should not be a shortcut activity. Everything should be done to make sure that all of the elements are efficiently and effectively executed. The plan approved is not doing that because the shortcuts are interfering with the effectiveness of things like claims and objections and other things. But that's administrative and it's not covered specifically by the law. But we also know that the question of the appeals in terms of submission of nominations, list of nominations, is also has to be clarified because that seems to be in breach of a statutory provision of our laws. Going beyond that, like I said, we were discussing up to the 20th preparation for elections. Separate and apart from the work plan which was before us, there were about 5 elections-related issues before us, the impact of which can determine whether we have a free, fair, and transparent election.
Could we come back to those? I want to bring our viewers up to scratch with how responsible governments operate when it comes to naming election. There's a particular letter that I'd like to share with our viewers. And I'll read this letter out while it's on the screen. This letter is dated March 20th, 2019. And it's addressed to Mr. Bharat Jagdeo, Honorable Bharat Jagdeo, MP, Leader of the Opposition. It comes from the Minister of State, Ministry of the Presidency. It says, Dear Mr. Jagdeo, I write on behalf of His Excellency the President, who extends his best wishes to you. His Excellency has instructed me to advise that he had written to the chairman of the Guyana Elections Commission on the 13th of March 2019, requesting the commission's work program in the shortest possible time, which would inform the commission's readiness to deliver credible elections in Guyana. On the 19th of March 2019, the commission responded, and in the last paragraph of its 3-page letter stated, and this letter quotes from that one, I would proffer that the commission would be in a position to conduct general and regional elections no earlier than late November 2019, with an official list of electors having a qualifying date of the 31st of October 2019. I attach a copy of the letter from the chairman of Guyana Elections Commission to His Excellency for ease of reference. In the circumstances, I am instructed to inform you that His Excellency the President intends to shortly name a date for general and regional elections in Guyana within the framework provided by the chairman of the Guyana Elections Commission. Signed, Honorable Joseph Harmon, MSM, MP, Minister of State. This captures the spirit and letter of what the consultation, the process of consulting with the commission is all about. And it brings into sharp focus the responsible nature of a government and the respect it shows for the elected opposition in treating with a matter as important and as serious as general and regional elections in a country. What we have now is a shameful position, in my humble view as a citizen of this country, sir.
That letter also exemplifies my contention that we have established best practices and conventions as the question of determining the date for elections. and that what is being done flies in the nature, flies in the face of those conventions from two perspectives. It flies in the face of the convention from the standpoint of the kind of consultation that takes place before the president exercises his prerogative. But it also flies in the face of the convention in terms of the timelines. Because when GCOM advised President Granger, he was advising President Granger based on the conventional timelines. President Ali has now been advised in defiance of the conventional timeline. So there are two elements that this shows really where we have gone out of sync. One, is we are not observing the procedures in terms of how the president is advised. I think we have made that point in our public statements. And two, when you look at the manner in which President Granger conducted himself and the then chairman conducted herself at that time, this now flies in the face of what are the normal datelines that inform the advice, and that those datelines and that advice, in fact, did not simply originate from the chief elections officer. It originated from the plenary of the Ghana Elections Commission, from the collective of the commission, rather than the chairperson looking back into the administration and then stepping forward to the president to unilaterally advise him on when GCOM can conduct its elections, knowing that GCOM was having discussions, that those discussions did not point to the capacity that she suggested. It pointed to the 22nd of September.
When idiocy transcends the norm, you'll get comments from people like Brown up there on the screen that says that elections are governed by ROPA, which is the Representation of the People's Act, and that a letter from Harmon is not a requirement of ROPA. It tells you of the sad state of affairs in which we find ourselves in a nation when a citizen of this country can condone openly, publicly, irresponsible conduct in public office by saying that exercise of decency is not a requirement, that the respect for a commission, a constitutional commission by a government is not important, that respect for statutory and traditional timelines are not required in handling these matters, but that just simply, and I'm pretty sure that the person who cited ROPA is entirely unfamiliar with what the provisions
The
are. But
person is unfamiliar with the legal architecture, which includes the Constitution.
And maybe with moral decency too, but
our Constitution bequeaths GCOM with an obligation to conduct a free, fair, and transparent elections.
Yeah.
It is the same Constitution that gives the president the prerogative to call a date. Now, these two things cannot be seen in isolation. The two things have to be seen as the part of a system. And if the Constitution says you must conduct free, fair, and transparent elections, and the Constitution says the president can call the date, one would conclude that the president has to call a date in keeping with the spirit of the Constitution, that is, that GCOM is prepared to conduct a free, fair, and transparent election. And to go on further, these conventions that are being referred to are conventions intended to facilitate the freeness, the fairness, and the transparency of the election. So although these are not laws in themselves, they are grounded in ensuring that the supreme law of the Constitution is in fact adhered to. So some of these people who make these comments, they make them oblivious, out of ignorance,
Or desperation.
or well,
Or desperation. Some are paid to say these
desperation,
things.
which has some of them out of ignorance, because people who are paid to be letter writers and trawlers, they're not acting as a matter of thought.
No.
They're acting a matter of root.
Utensils.
They're utensils.
Yeah, we know they have a whole room of them, and they're paid to do this kind of nonsense. But we would just want to dispel from the minds of our more sane citizens. Talk to us, Mr. Alexander, on those 5 elements that you were going to a moment ago that were on the table for discussion at the Guyana Elections Commission, which now seem in jeopardy as we hasten to the 1st of September as opposed to the 22nd.
That takes us back to the last point I made, that our Constitution provides for GCOM to conduct free, fair, and transparent elections. In that regard, GCOM should be addressing any issue that challenges the conduct of a free, fair, and frank and transparent election. In that regard, there were a number of issues that were unresolved that poses a question about the conduct of free, fair, and transparent elections. And I go through those one at a time. First one has to deal with the Commonwealth citizens. Our laws provide for Commonwealth citizens to vote. That's what our laws provide for. Traditionally, we have allowed the Commonwealth citizens to be resident for 1 year to be registered and to vote. This present government, in amending RUPA, specified that Commonwealth citizens should be allowed to vote if they have residency for 1 year and are domiciled. So they've added another element. This is the amendment, domicile. We have not finalized in GCOM what we mean by domicile. If one looks to traditional practices, the word domicile means the person must exhibit an intent to make Guyana his homestead. So he must be resident for 1 year, and beyond that 1 year, exhibit that you intend to live in Guyana. You don't just come for a year to work. You intend to live, to make here the place your homestead. We haven't settled the matter. So we have not been able to deal in a registration process with Commonwealth citizens in their entirety because the element of domicility is to be determined. So we have a category of people who may be excluded because we have not concluded how to deal with them. This matter was raised. It was sent to the AG for his advice. The manner of the correspondence did not place the issue of domicility squarely before him. And his response was, continue how you did it in the past. And then you have in the commission a commissioner who says...
So there's an amendment
Yes.
that seeks to change how you do it.
Yes.
But an attorney general who tells you to continue doing it how you've done it all the time.
How he did in the past.
Interesting.
And a commissioner who comes to say, well, you've been doing it this way all the time, so what's the problem now? Right? So this whole question of rule of law and all of that becomes irrelevant to people who themselves would like to speak about the rule of law. So that's the first issue that's unresolved. Now, let me say something. Elections about numbers. Elections about numbers. And in Guyana, numbers are critical because the difference between parties in terms of the results is not large. Every vote counts. And therefore, every decision we take that does not allow for votes to be cast are impacting the possible outcome of our elections. They're fundamental. So if some Commonwealth citizens can't vote, though they have a right, it's going to be reflected in the election results. Second issue that was on the table was the question of the incarcerated. We have traditionally in Guyana not allowed the incarcerated to vote. Now, I may argue that that tradition has followed from the British tradition. But I may also indicate that the British have since adjudicated on this matter in their courts, and the courts have ruled incarcerators to vote. So anybody going to argue that
These are convicts as well as remand?
anybody incarcerated, convicted and remand. So anybody going to argue that our constitution follows on from what predated us, the British have changed. So what predated us has changed in Britain. But more than that, our constitution itself specifies who are entitled to vote, and it says every Guyanese citizen over the age of 18, except for those who are incarcerated because they've committed election offenses and those who are insane. And that's why we face with this problem of a bloated list, because all the people overseas, incidentally, many of whom have died, are still on our list. Because the Constitution says once you're a Guyanese and you're registered, you're over 18, once you haven't committed an election offense, in which instance you are suspended for 5 years from voting, or you're insane, you should be allowed to vote. But we have thousands of incarcerated people who are not being allowed to vote. And we are saying, let's address this matter so that we can produce a free, fair, and transparent election. The matter was being discussed. And incidentally, it's another matter in which they wrote the Attorney General. And I'm going to comment on writing to him in his own right shortly as a second matter.
But I have a question.
I think your question will correspond to my comment.
How can it even be contemplated that you reference legal matters for resolution to a person who has political interests and is actively a member of the executive that is a stakeholder in the electoral process?
You are quite correct. And his political interest is demonstrated in the way in which he combated with the legal officer of GCOM on a matter on which the legal officer was representing GCOM in the court. So he's in a position of conflict of interest, but based on some argument that GCOM is a constitutional body and he's the state's attorney, these matters are being referred to that person who's clearly biased.
And who acceded to that same office that he lays claim to by virtue of being on the list of a political party.
Definitely. So you have preempted what I was going to say on that matter. So the second issue is the incarcerated. And that matter was to be resolved. Again, it's a question of numbers. Are the incarcerated going to be allowed to vote or not? There are all sorts of spurious arguments that it's a security risk to have them vote, a lot of balderdash. The fact of the matter is the Constitution says that all Guyanese who are eligible should be allowed to vote. And we are prepared to present possible mechanisms for them to vote. They don't have to open the prison door and let them out in the street to go and vote. Prison officers vote during discipline services voting, and prisoners can use the same opportunity, the same time, so that we can make the administrative arrangements for them to vote without any question of security arises. So who speak about security? They're merely trying to find a reason to deprive the prisoners, Guyanese, of the right to vote. Bearing in mind, among those prisoners are people who are on remand. They've not been found guilty of anything. And that number is not a small number necessarily. We have people in there 7, 8 years on remand, and the cases have not been heard. And we don't want to allow them to exercise their rights. So that's the second issue. The third issue is the issue of how do we address this big question of people who are not in the country evidentially being voted for at the last elections. Something the PEP been running from. They don't want biometrics because biometrics will be able to solve that problem to some extent. And what we have proposed is that in the absence of biometrics, which we still want, but we're not saying, all right, you say you can't have that in time for elections. So we have even, in some regards, the time element has impacted the preparation, and biometrics has been taken out of the
Having been
table,
stalled for 5 years.
right? Having been stalled
Yeah.
for 5 years, we said, look, the Chief Immigration Officer by law, Regulation 40 of the National Registration Act, is mandated to provide to the Commission of Elections periodically the list of all Guyanese who have left and are away for an extended period. Now, those persons are entitled to vote, but the evidence suggests that people have been voting for them. And so what we are saying is, on your voters list, highlight those names as a measure to create the level of vigilance and alertness that would deter such persons from coming to or being allowed to be voted for. Deter persons for coming to vote for them, and deterring such persons from being allowed to vote. That matter, which again has to do with the number of votes that will be cast, was on the agenda to be determined, being actively discussed. It's not yet been determined. So that's the third matter. The fourth matter that was being discussed was the question of the local deceased. A law has been passed, RUPA has been amended, not RUPA, the National Registration Act has been amended, to provide for the Chief Medical Officer and the Commissioner of Police to provide GCOM with a list of reported deaths. Because not all of the deaths have been recorded with the General Registrar's Office. This is a matter of fact. Nobody's contesting that. So we're saying, to plug the hole, let's have the reports of the police, because in the hinterland sometimes there are deaths, and because of all sorts of reasons, people are buried, and there's no proper registration of the death. So let the bodies, the Chief Medical Officer and the police, give us a report. And so we can now delete those names from the voters list. That matter has not been settled, but the law provides for it. This same government here passed the law of RUPA, the amendment of the National Registration Act. That has not been settled. So we have the possibility again of their names being retained on our list, because we have not settled a matter that is a glaring matter that ought to be settled. That's the fourth. The fifth issue, in fact, there's six. The fifth issue is that political activists who are polling agents, if a polling agent is working in a place where he or she is not registered to vote, that polling agent is being denied the opportunity to vote. In a country where they said everybody should be able to vote. And we have suggested that there could be an amendment in the laws that provides for that person to get a certificate of employment so that he or she could vote. Because the workers get a certificate of employment. The transport workers get a certificate of employment, but the political workers are not getting certificates of employment. Or they be allowed to vote through proxy. So mechanisms for people to realize their franchise. That matter has not been determined. That's the fifth matter that has not been determined. The sixth matter that has not been determined is we have a provision that when you receive a ballot paper, which is one document, it should be stamped at the top and at the bottom. And when we come to the count, it is not stamped, then it's not counted. This is not fairy tale. This is what happens. Now, the fact of the matter is that we have had instances where when that one paper is divided to count for the general and regional elections, which is separate, to count for the general and regional elections, to count for the general elections, which is separate from the regional elections, that the stamp is on the one for the general and not on the one for the regional, or vice versa. And we are saying, if you have one document in the first instance, and before you divide it to do your count, you observe that on one half there is a stamp, and on the second half there isn't a stamp, then clearly there's an error.
That's administrative.
That's administrative. And we should find a solution to ensure that the vote, be it for the region or for the national, is counted. Because the fact it is the part of an authenticated document where one part is stamped, it's one document initially, means it can't be that somebody forge or induce a false ballot. It is attached to an authenticated document. That matter has not been resolved. That matter too has not been resolved. So there are some critical matters which GCOM has sat upon for 5 years, have not resolved them. Imagine GCOM did not want to do a review of its operations, which would have brought these things onto the agenda. We have put them on the agenda with the aim of having them resolved so we can have free, fair, and transparent elections. They are not resolved. And the chairman of GCOM, who's supposed to embody the spirit of what's happening in GCOM, tells the president that we are ready for an election without consulting the body of people who are dealing with important and critical matters to the conduct of a free and fair election. It's therefore my conclusion that when I say GCOM is unprepared, I'm saying that GCOM is unprepared to conduct a free and fair election because GCOM is aware of discussing elements that can enhance the freeness, the fairness, and the transparency. And by the chairman's advice, I'm moving towards the election on a work plan to the exclusion of those things. We are consciously not pursuing our mandate.
And contributing to disenfranchisement of several bodies of people.
And devaluing the votes of others. Because if you have evidently people who are not present being voted for, then the one man, one vote goes out of the window because you have instances where there's one man, two votes.
We wind down here, Mr. Alexander. There's a particular issue that many of our viewers, I'm sure, are interested in. When you had this press conference, you made the point that you've just made again, that the earliest possible date by which this could be done was being discussed. The date on the table is the 22nd of September. You pointed out the areas that were contracted, where timelines were shortened. You pointed out the deviation from statutory and customary practices and deadlines. And the response from some quarters in the news media that act sometimes, if not most times or all the time, as extensions of the PPP propaganda, came out with a report. Norton contradicts opposition commissioners when he says his party is ready for elections on the 4th of September. I do not know that there's a relationship between the position taken by the commissioners nominated by the opposition with respect to their work and the leader of the opposition's position regarding the state of readiness of the political entity that he leads. Talk to us a little bit about this, Mr. Alexander.
Let me say, first of all, recently Jagdeo has taken it onto himself to say who should do what. He even says what the PNC should do. Jagdeo, what the PNC should do. Takes it onto himself to do that.
Didn't mention Sue in the process, did he?
The fact of the matter is that when the PNC speaks about its readiness, It means that they have the workers in place. It means they're in a position to make the relevant nominations by nomination day, etc. It does not speak to GCOM's readiness. It speaks to their readiness. And their readiness has to do with the things that they have to undertake to be able to contest the elections. And then Mr. Norton says they're ready. It means we have our workers in place. It means we are processing our candidates, and whatever date y'all give us, these things will be in place. And so there's no contradiction between Norton's contention that the party is ready and the commission's contention that GCOM is not ready. That's quite a different matter. Now, some smart guy will go a little further to say, but how could you be ready for elections likely to be rigged?
Well,
No.
You're right where I want to be with the final question. How should Guyanese view election results emanating from the process that GCOM is managing that appears to be compromised even before the date was named? Yes, the opposition is ready. Yes, the opposition will contest. Yes, the opposition feels very strongly that it will secure a victory at the polls. The entire operation, however, and this is the opposition's position as it relates to free, fair, and transparent elections. The entire process, on the other hand, seems to be rigged. None of the recommendations coming from the observer missions that witnessed, observed, and reported on elections 2020 have been honored by GCOM. The position of the commissioners of GCOM are not being honored by its chairman. The work plan that formed the basis for the chairman's advice to the president did not benefit from prior consideration of the commissioners. And on top of all of that, Mr. De Silva is suing the commission for defaming him. The commission rated this gentleman as a high flyer in his review, which would precede the expiry date of his contract, which will become renewable upon expiry. But yet, because he dared to stand by the law, the same commission, by majority vote it seems, and we know what that means, decided not to renew Mr. De Silva's contract. All convenient operations. In the view of all of this, Ms. Alexander, what should be the general disposition of citizens with regard to the outcome of these elections?
Let me give you the Silva matter first. The Silva has not contested the non-renewal of his contract.
No, yeah.
We have laws that are, I would say, unjust, but they're in the law books. So in Guyana, if you have a contract,
defamation.
If you have a contract, your contract could be not renewed. Once the body of people contracting you give you 3 months notice. And that's what GCOM, in a sense, has used. His contract has come to a termination point, and they're doing a non-renewal based on the right of any entity not to renew the contract. What he's contesting is a defamation.
Contained in two press statements.
Contained in 2 press statements. And his motion is directed to the chairperson and to the CEO, because those are the persons who made those statements. And I dare say
In their personal or professional capacities.
they made them by virtue of the offices they occupy, but I dare say that motions are being brought against them, and not GCOM as a collective.
Well, I trust that GCOM wouldn't be paying for their
Right?
legal
But
fees.
that's another matter. So that is where it is in terms of the silver matter. But what has occurred with the silver is symptomatic of the state of affairs in GCOM. Now, I think political parties are in a quagmire on this question of contesting elections which are patently unprepared for. I think political parties have to make a decision as to whether they will not contest and allow the PPP to occupy all the political space thereafter. I think that's an issue political parties will have to ponder. Are you going to not contest, and then tomorrow morning the PPP, not only are they dictating, but they have absolute numbers in terms of voicing legislative issues and things like that? Parties have to make a decision. However, I would contend that in the circumstance of our elections, one may well argue that the government will be an illegitimate government, notwithstanding the conduct and the so-called winning of elections, that the government will be an illegitimate government. And in the circumstance of illegitimate government, it is up to civil society to continue to have civic action in response to the illegitimacy. Now, some of that civic action could be context in terms of political action. But what it really ends up with is people's action continuing the contestation of the legitimacy of the government with the intent that that would lead to a resolution of the problem. So the party could contest because strategically they don't want to give up political space. But at the same time, they could maintain their position about the nature of the elections. And as a body of people, could then be involved in continued contestation of the legitimacy of the government, notwithstanding the so-called victory at elections. In contesting, the party may even win. In which instance, if the party wins, I would expect that that party would seek to have the matters that are on the table resolved as quickly as possible and to return to the polls for us to have free, fair, and transparent elections.
That's where we come to an end for today's program. I'd like to thank you, Mr. Alexander, as always, for bringing your deep insights into elections matters and offering clarity to our viewing and listening public. It is the view, I believe, of the majority of voters in this country that for Guyana to grow, the PPP must go. Until we meet again next Sunday, by God's grace, have a safe one.